Good evening, ladies and gentlemen. Thank you for taking the time to join us today. My name is Sarah Altman, and I'm from the Amerika-Zentrum Hamburg. And on behalf of the Amerika-Zentrum Hamburg, the Deutsch-Amerikanisches Zentrum Stuttgart, it is my pleasure to welcome you to tonight's event on the Supreme Court of the United States. An event not possible without the amazing support from the US Embassy in Berlin and the Auswärtiges Amt. Thank you for helping us shine a light on this important American institution tonight. When the idea of this event was born, we had no idea how newsworthy and timely it would eventually become. For example, the ruling in Dobbs versus Jackson Women's Health, the case that could overturn Roe versus Wade, is expected in late June, perhaps even this Thursday or next Tuesday. We are honored to have Dr. David Goldfield with us tonight. He is the Robert Lee Bailey Professor of History at the University of North Carolina. Dr. Goldfield will talk about the importance of the Supreme Court and help us get a better understanding of its uniqueness. We are also giving a very warm welcome to our moderator tonight, Erika Barner-Seyfried. She is an experienced art consultant and freelance journalist living in Hamburg, and has moderated several events for the Amerika-Zentrum in the past, among other things, a panel discussion on Kamala Harris and the power of women in politics. And last October, we had the pleasure of welcoming Henrietta Lacks's great-grandchildren in Hamburg. So thank you again for joining us tonight, and enjoy an interesting and important lecture and discussion on the Supreme Court of the United States. So without further ado, I am happily handing over to Erika. Erika, thank you.
Thank you, Sarah, and thank you, Dr. Cole and the German American Center in Stuttgart for having us here tonight. It's my pleasure to introduce to you my homeboy, as we would say in American English, Dr. David Goldfield, who is also a native of Tennessee, hailing from Memphis, whereas I come from Nashville, the country music capital. Dr. Goldfield is the Robert Lee Bailey Professor of History at the University of North Carolina in Charlotte. We're so happy that he could join us today after just returning from travels in Northern Ireland, where he was part of a committee or coalition who celebrated the 50th anniversary of commemorated the 50th anniversary of Bloody Sunday there in Northern Ireland. He is an active lecturer at the University of North Carolina in Charlotte, presenting lectures in the history department at the graduate and undergraduate level. He uses his historical background as a conduit to resolve and solve conflicts in modern times. He is on the board of the International Coalition of Sites with Conscience, which is based out of New York and has offices in Brussels. And he joins us today from Charlotte, North Carolina. One of the things that this coalition does is they have a cadre of about 30 museums, which they advise on specific topics. Many of these museums are in Asia, the Middle East, and America. However, there are one or two museums here in Germany, which maybe he'll mention later. I want to say thank you, Dr. Goldfield, for coming to us this evening. It's a very important event or lecture that you will be presenting today. As Sarah mentioned, who knew that this topic would be so telling at this time with Justice Jackson becoming confirmed recently with the talk about Roe v. Wade and Dobbs versus Jackson. We have lots to talk about this evening. So without further ado, I'd like to invite Dr. Goldfield to say a few words about himself and begin the presentation. Thank you.
Thank you very much. Guten Abend. I appreciate the introduction, Erika, especially from a fellow Tennessean. There is one thing I do want to add. Yes, Nashville is the country music capital of the world, but Memphis is where rock and roll began. So I think we're at least on a level plane there. I want to thank the Amerikazentrum in Hamburg, the German American Center in Stuttgart, and my colleagues at the U.S. Embassy in Berlin, particularly Dr. Martina Cole, who has done more than anyone in the country of Germany to explore and promote the friendship between Germany and the US, and to understand particularly the United States on behalf of Germans. So let's talk about the power of the US Supreme Court. As Erica mentioned, it's something that most people here in the US don't think much about until now. And now we are experiencing questions not only about the Supreme Court, but other institutions of American government. The Supreme Court will rule in a couple of weeks, maybe even sooner than that, on the issue of whether Roe versus Wade will stand as the precedent in terms of providing women with the opportunity, with the right to end pregnancy. And this has resulted in a significant controversy in the US. Of course, we don't have the final decision yet. The decision was leaked. And by the way, leaking a Supreme Court decision is extremely rare. As a result, you can bet that this is going to be one of what we call a landmark decision. Now, during the course of my presentation, if you do have any questions, please feel free to raise your hand, or we will have a Q&A period following the presentation. So let's begin. Okay, this is the U.S. Supreme Court. It's a lovely building, and the U.S. Constitution called for one Supreme Court, but left it up to Congress to authorize lower federal courts. This was in 1789. The framers of the Constitution were deliberately vague about a federal judiciary because there was a conflict between states' rights and central government. And the folks who supported states' rights did not want national courts enforcing a uniform judicial system. So the Constitution is really vague about what the U.S. Supreme Court should do. And this division between those who want to see more rights for the individual states and those who want to see a more central, powerful central government, this has persisted since the beginning of our country. Now, here is Ketanji Brown Jackson, the first Black woman nominated and confirmed to the U.S. Supreme Court. She took her seat, was confirmed in April of this year, and she will become the 9th member of the Supreme Court once Stephen Breyer retires. She is taking his seat. So she is not yet physically on the court, but she will be once Stephen Breyer retires at the end of the court's session, which is going to be in a week or two. This was a controversial nomination by President Joe Biden. Controversial because she was Black, controversial because she was a woman, controversial because a Democratic president had nominated her. Normally, in the good old days, a Supreme Court nomination attained the votes of most US senators. In order for a nominee to take his or her seat on the US Supreme Court, they must be confirmed by the US Senate. And historically, these votes have been lopsided in favor of the candidate. The idea being that, well, the president has the right to choose, and unless the judge is not qualified, and that has happened on several occasions, then there is no reason for opposing that individual. Justice Breyer, for example, whom Ketanji Brown Jackson is replacing, received 92 votes out of the 100-person Senate for confirmation, almost unanimous. But we live in a different time now. We live in a more contentious political time. And Judge Jackson will sit on a court that has become significantly divided not by the law necessarily, but divided by politics. Now, here's an important point I would like to make. Politics has always entered into Supreme Court decisions, but the extent to which politics has invaded the court today is unprecedented in American history. And we'll see that history unfold. Any questions so far? Here are the 9 justices of the US Supreme Court. Now, it's interesting. You may be wondering, why 9? Why not 15? Why not 6? Why not 7? There is nothing in the US Constitution specifying a number of justices. In fact, in the early days of America, there were sometimes 6, 7, and only over the past 90 years or so has there been a court that has had 9 justices. So the number has changed over time. In other words, there's nothing in the Constitution which says, well, you have to have 9 justices. As I say, you can have any number, but the 9 has fixed the public impression of the court, and that has become a contentious issue in and of itself. And as you can see, there is 1 Black person, Clarence Thomas, on the Supreme Court, 3 women on the Supreme Court. And it's interesting, the Protestant religion is the dominant religion in the US, but 7 out of the 9 US Supreme Court justices are not Protestant. They're either Roman Catholic or Jewish. And I think that says a lot about the US. And it also says a lot about the US Supreme Court in that it's not a vehicle to reward a majority of Americans. It's a vehicle that tries to select the very best people to serve in a lifetime capacity. Now, of course, the Roe v. Wade decision, which was passed in 1973, has been a decision of contention for the past 50 years. There has scarcely been a year that's gone by that there are challenges to it. And the court has taken some of these challenges and has whittled Roe v. Wade down a bit in terms of when abortions can be performed, how long the fetus is in the womb. And individual states have passed restrictive laws on it. And the question becomes, how far can you go in whittling down Roe v. Wade without just eliminating the right of abortion altogether? This demonstration that you see, again, in front of the US Supreme Court building, took place in April following the leak of the supposed decision of the US Supreme Court that would state that Roe v. Wade is overturned. Now, keep in mind, it is very rare for a US Supreme Court to overturn precedent. Yes, they can modify it. They could change some of the applications of the law, but it is extremely rare that the Supreme Court will completely overturn a previous decision. The law in America is based upon precedent, is built upon precedent, meaning it's built upon previous law. So it is very rare that a law that has stood for 50 years would not only be significantly diminished, but would be outlawed and taken off the books entirely. Okay, let's go back in time. Are there any questions before we take our time travel?
We actually do have a question, if I can interrupt.
Sure.
Trista would like to know why the present-day Supreme Court nominations are so contentious. Can you give us some background on that?
That's a great question. They are contentious because our politics are contentious. As I mentioned, as late as the 1980s and early 1990s, Supreme Court nominations were not particularly newsworthy in terms of Senate confirmation because most justices received, if not unanimous support, then a very large majority. But after the mid-1990s, when our politics became more contentious, when the parties began to drift apart, with the Democrats moving slightly leftward and the Republicans moving significantly to the right, we had a system where confirmations, not only of Supreme Court justices, but of judges in the lower courts, ambassadors, anything that required a confirmation would generally be contentious because of these divisions in American society. Congress reflects American society, and we are a divided nation. And these divisions are evident in not only in Supreme Court nominations, but in particular, the vote to confirm or deny confirmation to a particular nominee. It used to be the idea was, well, the president was elected by the people. Therefore, he has the right to nominate whoever he wants to at the Supreme Court. To give you one brief example, President Dwight D. Eisenhower nominated 4 justices to the U.S.
Frozen?
Excuse me?
It might be my internet connection is unstable. I thought you were frozen. Excuse me.
I'm frozen. No, it's very hot here in North Carolina today. Okay, hopefully not frozen. But President Eisenhower nominated 4 Supreme Court justices, and he made very sure that each of his nominees would not be selected because of their party affiliation. So he would nominate, Eisenhower was a Republican, so he would nominate a Republican justice, then he would nominate a Democratic justice, then he would nominate a Republican justice, then he would nominate a Democratic justice. This type of appointment is totally foreign now. It would never happen in our contentious environment. Okay, does that answer the question?
I believe so. We do have another question about process, but I think you're going to get into how SCOTUS works shortly. Or would you like this process question?
Well, let me go through the Supreme Court history, and then we will, if I have not responded to that, then it would be a good idea to raise that question.
Okay.
Really, when you're talking about the U.S. Supreme Court, because it's so vague what it should do in the Constitution is a vague document. It was decidedly vague because there was a lot of opposition to it. So if you have a vague document, different sides can read into it whatever they wanted until some controversy erupts. The first real Chief Justice of the U.S. Supreme Court was John Marshall from Virginia. And by the way, most of the country was run by Virginians for the first 20 or 30 years of our existence. I'm just going to mention a few of the key decisions of the U.S. Supreme Court under John Marshall, because that really set the tone for what the Supreme Court would do, what decisions they would take, because they only take a small portion of decisions that are appealed from the lower federal courts. In 1803, the Secretary of State, James Madison, refused to deliver a commission to William Marbury, a federal appointment to William Marbury, made by John Adams in the last moments of his presidency. And keep in mind that James Madison and John Adams just did not see eye to eye on lots of issues, particularly after Thomas Jefferson became president of the United States. Marshall held in that decision, Marbury versus Madison, that although Marbury had a legal right to his commission, the court had no jurisdiction in the case. What he did was he conferred on a power on the court not specified in the Constitution. He stated, and I'm quoting him, that it's emphatically the province and duty of the judicial department to say what the law is. And that established what we call the principle of judicial review, which is the power of the Supreme Court to rule on the constitutionality, to say what the law is, to rule on the constitutionality of a particular case. And a number of politicians, particularly associated with Thomas Jefferson, objected to that, but the law stood. And it was a pivotal importance to the future of the Supreme Court, because basically the court today decides what is constitutional and what is not constitutional. There was only one time in American history when the court ruled a law unconstitutional and the president ignored it. That was Andrew Jackson, who had abolished a central bank. And John Marshall said that was Supreme Court Chief Justice, said that was unconstitutional. And Andrew Jackson said, well, John Marshall has made his decision, let him enforce it. And he did that not only with the bank, but also with Indian removal. But since that time, there has never been a president that has defied in such a manner a Supreme Court decision. Now, you see about the national bank here. The state of Maryland wanted to set up its own bank, but could not do so. Now, another key decision was the Charles River Bridge case. This was not a decision that was made by John Marshall, but rather by his successor, Roger B. Taney, who came from Maryland. And Taney was unusual because he was the first Roman Catholic justice. He was not only a justice, he was the Chief Justice. And that's, I think, a reflection of the US, particularly at that time. The Charles River Bridge case, Charles River Bridge versus Warren Bridge, the state of Massachusetts had given the Charles River Bridge a monopoly to collect tolls over the Charles River in Massachusetts, near Boston. And what the court ruled was that a state cannot create a monopoly. Our system of government thrives and our economy thrives on competition. So squelching competition is not going to be constitutional. And this particular decision was very important because it has been used throughout our history to limit or prevent monopolies in our economy. Perhaps the most controversial decision before the American Civil War was Dred Scott versus Sanford. And again, Roger Taney was the Chief Justice of the US Supreme Court. It was delivered in 1857. The background to this was that Dred Scott, whom you see here, he was a slave, and he was a slave of a doctor in Missouri. Missouri was a slave state, and from time to time, the doctor would cross the Mississippi River and go into Illinois, which was a free state. And Dred Scott sued because he said, well, in Illinois, I'm free, therefore I'm free. And the Supreme Court said, no, you're not free, Dred Scott. Why aren't you free? Because you're not a person. You're property. And this decision shocked many Americans across the country, because obviously Dred Scott's a human being, but the court did not consider him a citizen. In fact, considered him property. This decision was important because it gave a tremendous boost to a new political party in America called the Republican Party. And the Republican Party was an anti-slavery party. And it is not surprising that 4 years later, after the Dred Scott decision, that civil war tore America apart in the North and the South. As part of the Civil War result, there were 3 amendments to the Constitution. The 13th Amendment, which abolished slavery, and the 14th and 15th Amendments, which provided the right of the national government to enforce laws in individual states, and the 15th Amendment, which granted the right of Black Americans to vote. The key decision coming out of this was the slaughterhouse cases of 1873. And unfortunately, that Supreme Court decision rendered a very narrow definition of the 14th Amendment. So the upshot of it was that it gave the federal government limited power to enforce civil rights. And this was important because in 1873, there was an organization called the Ku Klux Klan. They were a paramilitary arm of the Democratic Party. Now, keep in mind, after the Civil War, the Democratic Party was really the only party in the South. When I grew up in Memphis, we only had the Democratic Party. That was it. Why the Democratic Party? Because the Republican Party was the party of Abraham Lincoln. The Republican Party was the party that freed the slaves. So if you were a white Southerner, you always voted Democratic. And the Supreme Court in the 1870s and 1880s and 1890s had almost all Republican appointees. So you would think that this gentleman we're looking at here would have won his case in 1896. That case was Plessy versus Ferguson. This is Homer Plessy. I know you cannot tell from this photo, and if you met him in person, you probably couldn't tell it either, but Homer Plessy was Black. And he sat in the white section of a train in Louisiana in the 1890s. And he was ordered out of that first class section, even though he had paid the first class fare. He claimed that under his right of citizenship, guaranteed by the 14th Amendment, the state of Louisiana could not discriminate against him on the basis of color. And the Supreme Court ruled 7-1 in favor of the state of Louisiana. The ruling said, as long as the accommodations are equal, they can be separate. Hence, the name we associate with this decision, separate but equal. And the Supreme Court added this statement: social prejudices may not be overcome by legislation, and lawmakers are powerless to eradicate racial instincts. And that was more important than the 14th Amendment. It is interesting that one of the few Democrats and the only Southerner on the court, Oliver Wendell Holmes, was the lone dissenting view. He said that Homer Plessy had paid the fare and had the right to sit in the white first-class compartment. Oliver Wendell Holmes came from a family that owned over 100 slaves. So we have the great irony here of Northern Republicans voting for second-class citizenship for Homer Plessy, and a Southern white Democrat, a former slaveholder, voting for equality. Between the Civil War and World War I, the Republican Party was dominant in the presidency until 1912, when the Republican Party split, and it gave the Democrats a chance to, at last, elect their president. Woodrow Wilson, who was a Southerner, again, the Democratic Party was extremely strong in the South. He was also president of Princeton University. And one of the first things he did as president was nominate, when a Supreme Court seat came open, was nominate Louis D. Brandeis, a lawyer from Louisville, Kentucky, again, another Southern state. Why is this important? Because Louis Brandeis was the first Jewish justice to sit on the US Supreme Court. And you can imagine the controversy this created in America, not among Democrats, of course, but among a number of Republicans. Nevertheless, he was confirmed with a good margin of votes. And some of the worst predictions about him from the economic elite came true, because he was one of the few justices to support the rights of working men and women, to support organized labor. But the point is that at several points in the history of the Supreme Court, you have a key nomination, particularly from a minority group, that tends to move the court in a direction more in keeping with the majority of the American population. Because at the time, more than 14 million immigrants were coming to the US, particularly from Eastern Europe and from Russia. Now, the Supreme Court, despite the presence of Brandeis, keep in mind, Supreme Court nominees are there for life once they're confirmed. So despite the presence of Brandeis, you had a number of older Republican holdovers. So Franklin D. Roosevelt in the 1930s got just fed up with it, because the Supreme Court kept declaring his New Deal legislation, the legislation to end the Great Depression of the 1930s, kept stating that these laws were unconstitutional. And so he decided that he was going to appoint 6 new judges. In other words, he was going to expand the court. There weren't any openings, but he was just going to expand the court. And here you see Uncle Sam on the left, sort of being surprised, and Franklin D. Roosevelt, the ventriloquist, as this is. This 1937 political cartoon was a caption, "Do we want a ventriloquist act in the Supreme Court?" criticizing Roosevelt's New Deal and depicting President Roosevelt with new judges likely to be puppets of FDR. Well, make a long story short, this effort failed, and it really discredited Roosevelt, because what he was doing, he was trying to politicize the Supreme Court. He didn't like the politics of the judges, so he decided that he was going to change the numbers so that they would confirm and affirm his legislation. And I point that out because this is from a picture from late last summer, and you can see here these are Democratic senators and congressmen, and you can see what it says: expand the court. So here we are again. Are we going to expand the court? My sense of it is that President Biden is not going to go there. The precedent with a very popular president, Roosevelt was a very popular president, served 4 terms. So I don't think that that is going to happen anytime soon. Now, I have to reveal to you that this is my favorite president, even more than Washington and Lincoln. He's my favorite president, Dwight D. Eisenhower, because he was fair. He recognized that the US was a diverse nation, and to focus just on a portion of that nation was not something that he would do. And in 1946, when he was still commanding general of Allied forces after World War II, his brother Milton, who at that time was president of Kansas State University, wrote to him saying, "Ike, I'm going to be teaching a seminar on the future of America. Tell me what I should teach. Tell me what's most important." And Eisenhower wrote back to his brother saying, "Teach about race, because that is going to be the defining domestic issue for the United States of America for the next several decades." Now, I can tell you in 1946, nobody in America was talking about race. When you talked about integration, racial integration, a Gallup poll indicated that 6% of white Americans believed racial segregation was good. 6%. But Eisenhower had this vision of America as an inclusive society. And he reflected that in his choices of the Supreme Court. He knew that there was a case coming up from Kansas and South Carolina and other jurisdictions on school desegregation in 1953. And he put people on the court when the vacancies occurred who would be sympathetic to having Black children go to school with white children. And the result was the Brown versus Board of Education decision in 1954, a landmark decision which ruled that segregated schools were unconstitutional, and that racial segregation itself was unconstitutional. It threw out the Plessy versus Ferguson precedent, which said, yeah, as long as their facilities are equal, it's okay, separate but equal. But the truth of the matter was that the facilities, the schools, the neighborhoods were never equal. Black Americans were clearly second-class citizens. And Eisenhower did that. Now, the other important moment in the US Supreme Court occurred in 1967 when President Lyndon Baines Johnson nominated Thurgood Marshall. I mentioned Thurgood Marshall because he was the attorney on the Brown versus Board of Education decision, a Black attorney from Maryland. And President Johnson appointed him as the first Black justice on the US Supreme Court. So we have the first Jewish justice, the first Black justice. And now, of course, today we have the first Black woman justice. Now, there's one other decision that I want to point out to you because it is extremely important going forward in America. The 1965 Voting Rights Act said that in these states that you see here, including my state of North Carolina, where not all the counties, but 40 of the counties, mostly in the South, had historically denied the right of African Americans to vote. And in 2013, the US Supreme Court ruled that these states covered by the 1965 Voting Rights Act no longer had to submit their voting plans to the federal government, no longer had to submit how they drew their district lines, their congressional district lines, because in doing so, you could not only limit the power of people of color voting, but you can also effectively disfranchise them. And John Roberts, in the majority decision, said that race really is no longer a factor in voting in the South. Was he kidding? Totally clueless as to the situation, not only in the South, but in the rest of the country. You see, one of the states is New York, California, South Dakota. So it's not only in the South, but other states have used these laws to either restrict or eliminate the power of Black voting in America. I mention that because today we are experiencing even more restrictions on the rights of Black. Not saying that states are passing laws that Black people can't vote, but using the drawing of districts, using the number of hours polls remain open, using the registration process itself to restrict, to limit Black voting. And that all derives from the Shelby County case. Shelby County is a county in Alabama, just south of Birmingham. So that concludes my presentation